Hello everyone, my name is Delgado. I am an International Climate Protection Fellow from the Alexander von Humboldt Foundation, and I am carrying out my investigation at the Ecologic Institute in Berlin. First, I would like to thank the IUCN for letting me be part of this Congress and share my research with all of you. I am from Ecuador. Do you know where is it located? Have you heard of it? Have you been there? Let me talk briefly about Ecuador. It is a small country located in South America. We are very famous for being one of the mega diverse countries around the globe. We have the stunning Galapagos Islands, a coastline full of mangroves, the closest point to the sun in our highlands, the Chimborazo volcano, and the astonishing Amazon region. Let me tell you a brief story. Most of you surely know about what occurred with Chevron and the Ecuadorian Amazon region. If not, I will try to virtually carry you to the Amazon region. First, I'll need you to close your eyes. Just imagine a river, a swamp, a small valley, and a forest. Add a big amount of tropical vegetation and a lot of animals, be it pink dolphin or a sympathetic ceiling monkey, any animal that you would like. Also add millions of microorganisms, even if you don't see them. Now, let them interact for a long moment. Be quiet and see how they fly, run, or swim. Even feel a bit of fear of their presence. Then let us think also that we live there, and your family before us did it too, for uncountable generations. Now, I start to hear some loud sounds, drills, heavy machinery, helicopters, and numerous of unknown noises that are getting closer to you. They are not stopping for a long time. Then, suddenly, everything is quiet. You cannot hear any more the playful animals from a while ago. Now, like you were on the beach and wanted to feel the sand and the sea in your hands, put them down and try to submerge them in the river. Take them out and look how a black, thick, viscous, and sticky liquid starts to flow down from your hands. You try to clean them up, but it's almost impossible to get rid of it. This is good oil. Spread it on everything that you're visualizing and finally imagine that this is your home. Although words are not sufficient, this is just a quick sample of what Chevron did to the environment and to indigenous peoples in the Ecuadorian Amazon region. Now open your eyes. Welcome to the Anthropocene. The last IPCC report affirmed that human activities are the main cause of climate change. However, we are not only responsible for climate change, it is possible to evidence human interference in almost every environmental matter. Just name an international environmental treaty and you will realize what activities humans are carrying out to destroy the environment and to destroy themselves. For example, CITES intends to protect endangered species. The Montreal Protocol was about ozone layer depletion. The Paris Agreement seeks to avoid Earth's temperature to keep rising, and so on. However, facts show that not all these treaties are fully effective. For instance, complying with the Montreal Protocol was reflected on the restoration of the ozone layer, which is remarkable. On the other hand, the 100% compliance with the Kyoto Protocol's first period commitments did not reveal a significant change on the state of greenhouse gases emissions. Indeed, the international arena sought environmental treaties' effectiveness through the enforcement of certain obligations. Nonetheless, enforceability in multilateral environmental agreements has not made any difference in the past years, as it is not being enough to change the unsustainable development path of contemporary industrial civilizations and prevent environmental collapse. As a response to all this matter, the concept of rights of nature emerged. Although it is not a novel concept, its legal recognition started in 2008 with the Ecuadorian constitution, followed by many other countries that will be appraised in a few moments. But what are the rights of nature? Rights of nature are not simply rights, and they are not encompassed only inside the legal world. They were constructed by merging different approaches, namely philosophical thoughts, scientific evidence, cultural heritage, legal development, and social participation that intended to create certain rules of harmonic coexistence between human beings and the natural world. As a summary, there are four foundational pillars of rights of nature. Number one, rights of nature recognize the intrinsic value of the environment and its elements. Number two, living and non-living organisms are interlinked, forming a mutual cooperational system. Number three, human beings are part of the environment without owning it. And number four, the environment and its elements have legal personality. Commonly, the rights bestowed to the environment are the following: the right to exist, the right to persist, and the right to maintain and regenerate its vital cycles. Narrowing the discussion, international law has not given much attention to this legal concept, except for some soft law instruments, including various IUCN resolutions. The international agenda has not discussed thoroughly this concept. On the contrary, it is remarkable what national law has done in contributing to the rights of nature evolution. The states have recognized these rights in different ways. For instance, adopting constitutional texts, such as the case of Ecuador and Mexico, legal acts, such as Australia, Bolivia, New Zealand, and Uganda, and court decisions, such as the case of Bangladesh, Colombia, and India. Yet, moving back to international law, at the regional level, the Inter-American Court of Human Rights, in its advisory opinion about the environment and human rights, made a notable contribution on our discussion topic. It defined the scope of the right to a healthy environment by relying on arguments that, in my view, have gone beyond the common conception of this particular right. Let us point out the court's main facts. Number one, the right to a healthy environment is an autonomous right, which means that its protection does not rely on other human rights. Number two, this right intends to protect environmental components like forests, rivers, seas, animals, and so on. These environmental elements have legal importance on themselves, even in the absence of the certainty or evidence of a risk to individuals. Number four, the right to a healthy environment also protects the natural world because of its importance to other living organisms with whom the planet is shared, which also deserves the same legal protection. Finally, the court acknowledged the ongoing tendency among mainly American states to recognize the environment's legal personality, and by so, the rights of nature. Now, how did the court reach to this conclusion, and why is this so important? Briefly speaking, the court endorsed the spiritual relationship between indigenous peoples and the environment by referring to its extensive jurisprudence on this matter. Then the court recalled the broadly discussed interdependence between human rights and environmental protection. It is important to mention that this advisory opinion cast aside the current anthropocentric viewpoint inserted in international environmental law. Rather, the court made use of the same foundational ideas of rights of nature to describe the scope of the right to a healthy environment. This ruling will serve as jurisprudence for future cases, and it will directly influence on states' behavior, such as the case of Colombia with the latest award from the Supreme Court regarding the Colombian Amazon region and the rights of nature. In addition, the court made clear that the stolen rights to the environment and its components is an emerging state practice. So, to sum up, there are some ideas that I would like to point out as sort of conclusions. Number one, despite the amount of multilateral environmental agreements adopted, environmental degradation still occurs. Climate change is a fairy tale for some politicians. Whaling and biodiversity loss are founded in commercial expansion. Exploitation of natural resources have been carried out in the name of economic development. Trophies are more worthy than endangered species conservation, and so on. Number two, indigenous peoples' cosmovision is influencing legal decisions regarding the environment at both national and international level. For instance, Australia, Bolivia, Colombia, Ecuador, India, Mexico, and New Zealand have founded the inclusion of rights of nature within their legal frameworks based on indigenous peoples' beliefs. Number three, the Inter-American Court of Human Rights referred to a consistent recognition of the right to a healthy environment to establish the need of delimiting its scope, which has the same basis as rights of nature. According to the court, there is a national tendency to recognize rights of nature. As well, this issue will lead us to further questions, two more questions. Could this national tendency, or in other words, this state practice, be the beginning of the formulation of the formation of a new customary international rule? It could be. However, due to its complexity, this question should be part of a future investigation. The second question will be is it time for international law to consider the rights of nature as an important concept to address in future environmental summits? If so, it should start to discuss issues such as their legal status, the efficiency, and the effectiveness and applicability of this set of rights. This whole discussion of rights of nature international arena, in my view, will depend on the state's political will. It has been evident how reluctant have been negotiators when demanded to take environmentally sound decisions. However, why should international law and any other legal system include rights of nature within their legal structure? Let us put it simple, just to protect life itself. Thank you very much for your attention, and please do not hesitate to let your remarks and questions on the comments box. Thank you very much. Have a good